raised in the problem scenario. You know, when the facts set out a scenario that involves Commonwealth legislation, you can just, and there's two pieces of Commonwealth legislation here, you can just assume that it'll be Commonwealth administrative officials making the decisions, and that the right place to challenge any decision is in the federal court or in the High Court. In practice, you know, it might be the High Court would be last resort. And in practice, it could be the Federal Circuit Court could have the right jurisdiction, but we're kind of worried about the federal courts as a whole and seeking judicial review there. Okay, so what's important about getting that jurisdiction right? Well, the main reason is that at the Commonwealth level, the ADJR Act might be relevant. And if it is relevant, you have to worry about the threshold issues for the ADJR Act. So ADJR Act is a good option because the plaintiff can get reasons for decision. There's some easier, the grounds of review are clearly set out. The remedies don't have the technicalities. There's no requirement for jurisdictional error. ADJR Act can be better, but to bring the case there, it has to be a decision of an administrative character made under an enactment. Okay, so you need to think about that for Commonwealth questions, and you'll see the second question is about New South Wales. We don't have an ADJR Act equivalent in New South Wales, so you don't have to worry about it there. Okay, so do you worry about it here? Well, we have this clause down here, section 18. Decisions of the tribunal must not be challenged, appealed against, reviewed on any ground other than conscious maladministration. Conscious maladministration is a dark ground. That's leaving plaintiffs with very, very little. The one case that we have that deals with that is a case called Futuris, and the High Court said, look, you know, where it's going to be very hard to persuade us that there's been conscious maladministration. So we have a privative clause, pretty much a privative clause there, and then we have a time limit clause in the second sentence of that section. And that time limit clause actually will be engaged because the tribunal has made its decision on the 5th of April, it's published its reasons, affirmed the decision, we're told that's on the 5th of April, and then we scroll down and find that our plaintiff, Mr. Bean, is told of that at the end of May. So there's 6 or 7 weeks, and the time limit clause is 15 days, so 3 weeks. So that's a problem. So the first thing you have to do when you see this is recognise that's a problem and deal with that. Will a time limit clause stop Mr. Bean from bringing the challenge? Very unlikely. Why is that? Well, we have one case on time limit clauses, a case called Bodra Daza, and the time limit clause in that case was 84 days, like a much longer period, but it was a strict time limit, no flexibility. And this is the same, it's strict, there's nothing about flexibility in here either. And it's not his fault that he was told 7 weeks after rather than within the first 15 days. So the courts look for flexibility, and if there's, they call it, you know, that the time limit provision has to allow for vitiating circumstances. This one doesn't, so it's very likely to have the same problem as in the Bodra Daza case. So that's the time limit clause. Then there's the privative clause. Will the privative clause work? Will it stop Mr. Bean from bringing a challenge or an appeal or review or questioning the tribunal's decision? So we know that it's not going to work. And why is that? It's called, because of the Plaintiff S157 case, tells us that under the Constitution, it's you can't exclude judicial review, And also the trick that they used in Plaintiff S157 to say that to enable the courts to review decisions made under the Migration Act. The same reasoning process can be used here. Section 18 protects decisions of the tribunal, and you can say that some action that the tribunal has taken, a kind of purported decision, if there's a jurisdictional error, the courts will treat it as no decision at all, which will mean that the privative clause will not protect the tribunal's decision. Okay, so that means that, so what does that mean in practice for answering a problem question? You can still advise on grounds of review and how to make the challenge, but all of the, in order to get the remedy, all of the grounds of review that you have to show are possible and likely or arguable, they have to be ones that can be recognised as involving a jurisdictional error. That's what's required because of this privative clause. Okay? So the grounds of review that are not going to get you the jurisdictional error, they're not arguable there, or you have to show that if there's uncertainty, then it should be regarded as a jurisdictional error anyway. Okay, so that's the important thing there. Now, if this clause wasn't there, if the privative clause was not there, the best option would be to try to use the ADJR Act. You'd have to show there's a decision of an administrative character made under an enactment. Now, so that would be your best option then. But because the privative clause is there, it's very likely that the ADJR Act will be excluded. Actually, most practitioners and teachers would just assume that the privative clause will mean that the ADJR Act is excluded. Why? Because it seems to be written in a way decisions must not be challenged, appealed against, etc., etc. That's likely to be kind of inconsistent with the ADJR Act. This is a later piece of legislation. This piece of legislation would prevail. What would help is if the section also, if the facts also said something about whether the ADJR Act was expressly excluded. The way to expressly exclude the ADJR Act is to say there's a part of the ADJR Act where Parliament can add decisions under particular acts that are excluded from the ADJR Act. It's called Schedule 1. Schedule 1 has about 30 or 40 different acts, decisions made under it. In practice, not in this problem question, but in practice, if there's a privative clause in the Migration Act or in the Tax Act or something, the ADJR Act would also be excluded. There's a note put in Schedule 1 saying ADJR Act is excluded. It doesn't say it in this problem question, which creates a little bit of uncertainty, but the best way to think about it is that the ADJR Act will be excluded. Okay, so what are the issues then for Mr. B? There's lots of issues, lots of potential ways to fight this decision. So the real decision that we want to challenge is the decision of the tribunals, right? And we'll start with the strongest, the easiest grounds. And the strongest, easiest ground is likely to be procedural fairness, right? A breach of procedural fairness. People who looked at this before class will very likely have found procedural fairness breaches. So there's numerous things on the facts that suggest that there's a breach of procedural fairness. The first one is at the hearing. The tribunal has kind of dumped all these hundreds of pages of documents on Mr. Bean the night before the hearing, I think it was. But it turns out only one of the documents in this huge package is something that Mr. Bean hasn't seen, isn't aware of. And so usually if it's adverse information, that should be disclosed to him and he'd be given an opportunity to respond to it. That's what procedural fairness requires, right? Disclose if it's adverse information, given an opportunity to respond to it. It is adverse because the university report says that these vehicles have safety risks with them. So he asked for an adjournment. The adjournment is refused, and it said the reason for the refusal. The reason for the refusal is that he would give the report no weight in actual decision. Is that fine? Is that acceptable? To say, oh, you know, I'm going to give this information no weight anyway, so therefore I'm not going to give you the procedural fairness. Does engage with the case. It's not okay. Not okay. Do we know the case that tells us it's not okay? Which one? No, not Pico Wilson. No, another one. No? Yeah. DEAL. Yeah, DEAL. That's it. So the decision maker in that case, it was about confidential information that was adverse. And the decision maker just said in their reasons, oh, I haven't given that anyway, so it doesn't matter that I didn't disclose it to the applicant. But the High Court said, no, that's not how it works. If it's, I think it's credible, relevant and significant information, if it's relevant, you know, that way, then it has to be disclosed. And so that's what this is raising, that this DEAL case is likely to mean that information did have to be disclosed, even though the decision maker thinks they're going to give it no weight. Okay, so the other issues really for procedural fairness, or there's a hearing rule, more hearing rule issues, and there's also a bias rule issue. So, what are the other hearing rule issues? Okay, so the initial decision maker has refused to grant the certificate, and they just stated something very briefly about the roll bar. And then in the tribunal, it starts off about roll bars, and then it starts varying into all these kind of broad-ranging issues about his fracturing his foot, about, you know, this, what's it called, off-road racing being really dangerous, that there's going to be environmental degradation. I think the dangerousness is probably okay, but it's going to be environmental degradation, and there may something about the medical system may be strained. Okay. The fact that the fact that these issues are raised in the reasons, is that how does that relate to procedural fairness? So it's adverse information, right? For one, they're adverse issues and adverse information, so usually they have to be disclosed. But also, they're beyond what was said by the initial decision maker. And we have a case that the High Court said, well, you know, in these merits appeal kind of scenarios, the applicant can just assume that the same issues that the initial decision maker considered are going to be considered by the tribunal in the merits review case. And so if that's, you know, legitimate for the applicant to assume that the same issues will be dealt with at the tribunal as well as the initial decision maker, then procedural fairness requires additional issues to be disclosed and they be given an opportunity to be heard about them. Which case is that? Coppin?
Yeah.
No, no.
Maya? Is it Maya?
No, not Maya. It's one called SZVEL. I think I'll just open my yeah, SZVEL. Okay? So he was, I think he was the guy who was from Iran, and he jumped ship from the cargo ship he worked on at Port Kembla, and the tribunal raised all this stuff that the initial decision maker didn't raise. Okay, so that's the other procedural fairness issue. It's possible that you could find more procedural fairness issues if you dug around. Okay, and then I said that there's a bias issue. This is the Coppin issue. So what's the bias Coppin issue? Anyone remember what Coppin is about?
Something like Club One. And the lady was, something she just said took into her own experience from the decision.
Her own experience.
Yeah.
Because she was kind of mediating a discrimination dispute, and she said, and it was because these Aboriginal people were refused entry into a nightclub, and she said, "Oh, my daughters were refused entry into that nightclub," and then the nightclub owner immediately said, "Well, that means you're biased, and that this mediation thing just has to stop here." So, is anything like that here? This guy is saying. So the tribunal guy, he's saying, he fractured his foot. Doing this off-road racing leads him to think it's extremely dangerous. That's adverse to Mr. Bean. That's the claim that he's biased. Is that enough just to make a claim that he's biased? So we can use Coppin to say that this looks like, what we call it in our course outline, extraneous information. But it's kind of personal information. They're relying on stuff that they know about to make the decision. So what do you need to do when you're making a bias claim? There's kind of a two-step test. It's called the Ebner test, Ebner 2 steps. They said first you've got to start off with your claim. What kind of bias is it? And then you've got to show that there's a connection between that form of bias and the decision that's being made. So, tribunal member saying, well, I fractured my foot, I think it's extremely dangerous. That, along with a few other reasons, support the conclusion that the certificate should not be granted. That's the direct link between that's the link that you have to show to say there's a connection between his personal information that's now affected the decision making, and it's affected the reasons. It's straightforwardly included in the reasons with some other factors, but it's definitely in there. Okay, so when you're arguing bias, it's a good thing to argue, to point out the Edna 2 steps and how that will work. What I didn't say to you, and which I should have said at the beginning, is with the procedural fairness issue about the hearing rule, there's an initial step that has to be taken that I didn't take. So I would have been like, I would have put a little squiggle or something in the margin of the exam paper if for it. And what's that? What did I miss?
Implication.
Which one?
Implication.
The implication principle. Procedural fairness, you have to argue that it's required, right? So the implication principle primarily comes from Kiora and West. And it's not hard here, it's easy. It's that, is our applicant, Mr. Bean, is he personally affected by this decision? Absolutely, it's just about him. The whole thing is about his application for one of these certificates. So he's personally affected, there's no doubt about that. That's the first step. is procedural fairness excluded? There's nothing expressed about excluding procedural fairness in, it has all the standard stuff about conduct of tribunal reviews, although it doesn't add procedural fairness. So often they do have it somewhere in there, but it says nothing about it. But to exclude procedural fairness has to be crystal clear, right? We've seen a few cases, and in most of the cases about exclusion, the judges say, no, there has to be really clear before we'll accept that procedural fairness is excluded. Okay, so procedural fairness. All right. So then the next issue is this time to provide reasons. Now that is a statutory requirement that the reasons are provided to parties within 12 days of the decision being made. And if you scroll down, you see that the decision is made around here, 5th of April, and then reasons are published then, but they don't actually get to Mr. Bean until end of May. So this statutory requirement has been breached. Now, Mr. Bean doesn't just want reasons and within the time limit. He wants the tribunal's decision to be quashed and sent back to them and to be made again. So can he argue, this is the issue, this is the legal task that the applicant would have to make. Can he argue that this breach of the requirement to provide the reasons in 12 days, does that mean that the decision to not give him the certificate is invalid? No, probably not. Probably not. Yes. Yep. Can you expand on that?
So if just because there was a delay, then the decision is invalid. Sorry, I'm thinking maybe they shouldn't just say we have to grant him the.
Yes, so they can't do that.
Yeah, right. Maybe I'm confusing it. Sorry.
Okay. So what case is the important case that will be used to answer this question?
Try again. Project is.
Yeah, that's the one. It's very, very interesting in these revision classes that students often know the points, but not the name of the cases. So that's good. Okay, so the Project Blue Sky is, a crucial case, right? For this course and in practice. There's some people who think that Project Blue Sky, there's a risk of it being kind of everything about administrative law is in Project Blue Sky. So what does Project Blue Sky says that it's one thing to say there's a breach of a statutory requirement, another thing to say that the actual decision is invalid. Now, it could be that the decision is invalid if there's a breach of a statutory requirement. It's saying you have to make an argument. And so it could be a bit hard, right? Because you have to say that the time limit is an essential condition of for the decision to make for the tribunal to make its actual decision. So the decision has already been made, and there's a 12-day time limit after. It's going to be a real uphill task to say that is one of these essential preconditions. The best answer to answer this question would go through the factors that the judges referred to in Project Blue Sky. Is it one of these essential preconditions? That's the first one. Is it a vague concept? Indeterminate was their word. And is it going to cause inconvenience to other people? So it's not indeterminate, and it's unlikely to cause any inconvenience to anyone. But is it one of these essential preconditions? Probably not. What would that mean? It's been breached. They may give some weak remedy, but not the remedy that Mr. Bean wants. Mr. Bean wants the decision to be invalidated. Now, another way to see this is to see this as saying, is breach of this a jurisdictional error? And that's important because there's a privative clause here. All the errors that you have to advise your client of have to be regarded as jurisdictional errors in order to get around the privative clause. So breach of this may not be regarded as a jurisdictional condition for the tribunal's actual decision. Okay, so now if we could bring this case under the ADJR Act, if that was possible, could we get the remedy for Mr. Bean then? Much better chance. Because all you have to show then is that ADJR Act Section 5(1)(b) says that the breach of a procedural requirement, and this can be regarded as a procedural requirement, has to be in connection with making a decision. And that's our case that we've seen on that suggests that it's easier to prove that than what it would be to prove that this provision must be regarded as an essential preliminary precondition kind of requirement. Okay, so when you're revising this, just think through how this Project Blue Sky will relate to this Section 17. We don't really have time to deal with it now, but you might also think, is it also possible that this requirement to provide reasons has been breached? In a way it may not matter because it's hard to get the remedy for it. But you know, you might want to just think that through anyway. Okay. What else is there? Okay, in the reasons, the decision maker has referred to environmental degradation and what's the other thing? And this strain on the medical system. And you know, you might read this and think, oh, you know, the tribunal decision maker is kind of, you know, risking going beyond the kind of factors that are allowed to be considered under this safety legislation and legislation to certify, I think it's importing goods, importing these particular goods. So so then the question is environmental degradation and the strain on the medical system, are they considerations that they can be taken into account? Or could they be regarded as irrelevant? Well, it might be hard to argue that they're irrelevant. The main Australian case on that is a case called Murphy-Orrs. And Murphy-Orrs tells us that in that case, Justice Stephen had to work out, actually a similar scenario to this, come to think of it, that Justice Stephen had to work out whether the applicant in that case wanted to export these minerals, this sand, these particular minerals that came from sand mining. And the minister wanted to take into account environmental impacts on Fraser Island, which is in Queensland. And the mining company said, look, you can't take into account environmental impacts for an export permit. What does environmental impacts have to do with exporting these minerals? And Justice Stevens said, no, it's okay because it's okay to consider environmental harm because the Act dealt with lots of different things. And because the Act, or I think there's regulations as well, covered such a broad range of material, then it was acceptable to consider environmental harm. So how does that work in this case? Well, the legislation here says the Vehicle Safety Office may grant the certificate if they're satisfied of the standards and it's in the public interest to grant the certificate. So the two factors that have to be considered are the meeting Australian standards and the public interest. And public interest is thought to be this very broad consideration, which means that the courts would likely say, well, you know, under this public interest, lots of different things could be considered, including environmental harm and including strain on the medical system, on the health system. So, it's the inclusion of this makes the legislation similar-ish to what was considered in the Murphy-Orrs case. Okay, so it might be hard to argue that those considerations are irrelevant, shouldn't have been considered. Okay, so the last thing is, how likely is Mr. Bean to succeed, and what remedies can he seek? Okay, so there's been issues that look strong and some that are weak or not really arguable. And there's a privative clause, right? So privative clauses limit the remedies that can be granted. So what grounds are the strong ones? Procedural fairness, right? There's some pretty easy arguments for them. So then to get, because there's a privative clause, Mr. Bean can just get certiorari on the basis of jurisdictional error. So can he show that? How can he show that certiorari should be granted on the basis of jurisdictional error? It's because procedural fairness is accepted as being, or breach of procedural fairness is accepted as being a jurisdictional error. We have a case that directly says that in topic 10, a case called Arla. Arla, right? So to give the really full answer, the answer that there is really asking here, you need to say, well, the only strong ground that we've seen is the procedural fairness one, and he should be able to get the remedy of certiorari because procedural fairness is accepted to be a jurisdictional error. We've had, at least Arla says that, our big privative clause case, plaintiff S157 says it as well, and refers to Arla for the point. So we're on pretty strong ground that he can get a remedy in some way. All right. Anyone raise any other issues? Have got any questions?
So you said that it might not be under the ADJR Act because of the bias, so it would be under the Sharia Act.
Yeah. Okay. All right. So there's a little bit of uncertainty there, and because that clause might wipe out the Judiciary Act as well. So the thing is that with the federal court, the way the court see it is that the federal court's judicial review jurisdiction is granted by legislation, either the ADJR Act or the Judiciary Act. So what Parliament does by legislation, they can also kind of take it away, right? So then that doesn't completely wipe out judicial review, does it? Doesn't, because the High Court has its judicial review jurisdiction protected. So the safest answer to that is, well, the last resort would be the High Court. And we definitely have that option available. Well, but there may be uncertainty about the others. Yep.
To deal with the remedy issue in exam, do we have to go through all the grounds and to say, to analysis are the grounds deserve certain remedy, or we just pick up the strongest one to say certain remedy? can't be granted because of the strongest grounds.
So the question is, should you refer to the remedies for each ground that you're arguing?
Yeah.
Or should you just deal with it at the end? Is that what you're saying?
I'm asking, shall we just, for example, to mention the strongest grounds only?
Oh, okay, yeah.
Or we
Okay.
have to go through all the grounds we put in?
Well, I think, okay, so in this question, there's lots of issues, like lots, a real lot. It's a really dense question. So for this one, you'd want to aim for the strongest grounds, like pretty much the whole way, I would think. And then when you have to get to the remedies, it's just just the strongest ones, rather than list them all out. I think that's the answer. I hope that answers your question. Yep.
What about the fact that he didn't let give evidence of the domain, and then he was like,
Yeah,
well,
okay.
it isn't good.
Right. So I'm a bit unclear about that bit of it, actually. I'm not quite sure what issue is raised there. My take on it initially was, well, maybe this part of the mechanic. So the mechanic kind of comes back into the reasons here, and the tribunal member is saying it's not clear on the evidence here, and it has to kind of make these inferences anyway. And yet it has to do all that, even though Mr. Bean wanted to call evidence would have clarified all that.
Not the inquiries, like, yeah, like didn't make inquiries.
Yeah, actually that's good. You're right. So that's the Prasad principle, right? That's what you're getting at?
Yeah.
Prasad, right. Failure to make inquiries. Yeah, that's arguable. I think that is arguable. That's better than what I got from it. Other students in my class this morning said that maybe you could see it as illogical fact-finding, that they're having to resort to these inferences when real evidence was right there, and you didn't allow the real evidence to be provided. That could be regarded as illogical, and we can tie the illogical, irrational fact-finding. You can handle that in a couple of different ways. When I read it, when I was looking through it yesterday, I was thinking maybe the reasons are inadequate. There's a requirement in the reasons here, up here for shall include findings on material questions of fact and reference to evidence on which findings are based. So here's the tribunal members kind of got themselves in this situation where they can't refer to evidence, and so they have to kind of guess at it instead, which could be the basis for inadequate reasons, but inadequate reasons aren't going to get you very far, because that's probably not going to be a jurisdictional error. Why is that? We have a case that tells us that it'll be hard to show that inadequate reasons will be recognised as a jurisdictional error. That case is Palm. Okay, so we'll take a break there, and then we'll come back with question 2.